morning. Normally you start with your chairman, but I can't say that. So, Raghavender, John, Jyoti and Hari, and dear participants. It's such a great pleasure to be here 1 week after the last event. I see that 7 out of the 14 topics today, or sessions, 7 sessions have AI or metaverse or anything to do with the digital world. And the field is, of course, rapidly evolving from voice recognition to self-driven cars. The first question that arises is, what is AI? And there are all sorts of definitions, but a narrow, highly focused definition has come from the European community in their EU regulations of April 2021, which of course have not become final because they've been passed by the Parliament and the Council, but the Commission has to also say yes, and that's when they become final. In European law, that's the rule. All 3 of them have to say yes. Still, they are extremely valuable, and they define AI as software developed by technologies such as machine learning, etc. There's a longer line of technologies to achieve human desired objectives or to generate outputs, recommendations, decisions, and predictions. Now you notice here immediately that this is limited to software, which is a bit narrow because hardware and algorithms and data sets are all part of the package that makes AI. But for the purposes for which they have made those regulations, they are quite useful. At the same time, there are various industry groups that are opposing these, such as the military, and there's a clause there that says these regulations will not apply to military, which is quite kind of startling for the reason that autonomous weapons is probably the biggest risk posed by AI today, and so why should they be excluded totally from a set of regulations on AI is anybody's question. But when I asked it of some people who are involved in the process, they said because the military has a lot of political muscle and they made sure that those regulations don't apply to them. At the same time, the AI community is opposing them, and the entertainment industry wants these regulations because they are the ones who are suffering impersonation, fake news, and a lot of violations of personality and publicity rights. Because of this evolutionary process of AI, some of the objective articles have classified the stages as being 10, and they say that we are on the 4th level just now. So it started off with rule-based algorithms where you wrote the program, and then it went on to data-driven programs like AlphaGo defeated the world champion in the game Go. Lee Sedol was defeated, the Korean. And the number of moves that the game Go can, or possibilities that exist, are more than the number of atoms in the universe. And despite that, picking up from past games, data-based, that game, that program, AlphaGo, became the world champion. We have to go through future stages such as artificial general intelligence, transactional intelligence, cosmic and divine intelligence. This is when AI will gain deeper understanding, reasoning, emotions, awareness, and even predicted to have consciousness. That's the time when AI would not want humans. And this is not science fiction. This has been seen by the leaders of the AI world as a reality. So, big experts talk of big risks, such as Elon Musk and Jeffrey Hinton, who's called the godfather of AI, or Bill Gates. All of them have cautioned us about these big risks. One of the risks is bias. And a perfect example, which a lot of you may have read, is when AI confused a husky from a wolf, when it had been fed with a lot of data on both. But it saw that the wolves were always on snow, huskies were always on ground like grass or concrete ground. And so when it saw a husky on snow, it called it a wolf. And they were able to, because of the transparency of that mysterious black box, they were able to understand why that bias had crept in. The autonomous weapons are a real big risk when the weapons can decide which target to hit and what power to use. The weapons will decide on their own. The US regulations have come up which talk about do not target civilians, things of that kind, or self-destruct and self-deactivate provisions, but there is no ban, which is very startling that there is no country in the world that has banned autonomous weapons, or rather AI used to create autonomous weapons. EU regulations, like I said, actually exclude military. The second risk is deepfakes. The Prime Minister, our Prime Minister, on the 23rd of November, has actually cautioned everybody on deepfakes and said that we must take immediate action. And he gave the example of compulsorily using watermarks on AI-generated content. Various countries have taken actions. We have EU Article 9, which talks about risk management and the efforts to mitigate, identify risks, and then efforts to mitigate those risks. And a very good example which comes up or can be given is of the Upar fire, which took place at a cinema hall and killed many people in Delhi, where they found that the transformer had not been properly placed. There was no ventilation, and 52 extra chairs had been provided at the fire exit, thus obstructing people who wanted to get out. That kind of analysis is necessary for AI systems and a mitigation strategy. In India, we are working assiduously towards this. For example, Niti Aayog has come up with draft principles, 8 principles, which you must read. Fairness standards for bias has been taught. TEC of DOT has come up with those of the Department of Telecommunications. TRI has come up with recommendations, and there is a discussion which is going on. I won't even call it a discussion paper so far. It's just a minister's speech on the Digital India Act, which will have substantial provisions on AI. Various other countries like Australia, Singapore, USA, China have come up with guidelines or regulations or executive orders which are aiming at obtaining safe, secure, transparent, and reliable artificial intelligence. Let's look at IP for a moment. We have patents to start with, and the filing of patents has increased to the point that the WIPO latest report suggests that in 2 years from 21 to 2023, there was a rise of 367% in AI-related searches, patent searches. Software in India has always posed a Section 3A problem, and that's overcome to an extent by showing that there is a technical effect, and courts have started to recognize the technical effect not only to have a tangible end product, but something which is a physical entity. It could be an image, it could be a signal, and still you could show technical effect and overcome the 3K problem. But one of the deeper problems, which is common to copyrights and patents, is who is the inventor or who is the author? And can AI be the inventor and the author? And it appears, and I may be wrong here, but according to my research, it appears that most countries have said no, AI cannot be a copyright author, except China. China has said it can. And the Dabas case is something which is probably known to most of you. The question is, the Indian Supreme Court has recognized an idol, which is stone, to be a person and to have the capacity to file lawsuits. A forest can file a lawsuit. An animal can file a lawsuit. They are all recognized as persons under Indian law. The question is, without a legislation, would there be a future court one day in India who might say that AI is no less than stone and therefore should be recognized, if not as the sole author, at least as the co-author with the human. In the field of copyright, the other two issues that arise are that if there is data which has been input to create the algorithm, then the ultimate work which is generated, if it violates that, if there's copyright in that input data, then does that infringe? Or a second question, the ultimate work, does it have copyright? And these are questions which are arising. And the answers have yet to fully fructify, and there is not yet total unanimity on these. There are only theories right now. Then, in trademarks and personality rights, we had the Anil Kapoor case, where fake pictures of Anil Kapoor were created using AI programs, and some of them, one of them was a cross between Anil Kapoor and Katrina Kaif. Anil Kapoor's face, Katrina Kaif's cover. Another one had Anil Kapoor as Mickey Mouse, and of course we went to court and we got that injuncted. The question is, will all courts in the country pass that kind of a comprehensive injunction? That's one of the problems with these sort of cases, because a lot of the district courts in the country will not even recognize or appreciate some of the concepts that we have in AI. On fake news, we had a horrible case where Mr. Amitabh Bachchan's granddaughter, Aradhya Bachchan, was declared to have cancer by one of the blogs, and to another blog declared her dead. And then, of course, we stopped that in the Delhi High Court. But more importantly, the court came up with a principle, but Google took a defense that they cannot, that their guidelines don't permit them to take it off. The court said, if your guidelines do not permit child pornography, how can they permit the declaration of a child as dead, when the child is very much healthy and alive? So the court said, you must bring it down. Google said 48 hours. The court said immediately. Immediately means immediately. And the court said there will be zero tolerance, that's the word used in the judgment, zero tolerance when it concerns children. That was a remarkable way to react to a situation like that. The dark patterns are a new area. Advertisements that have a false or a fake message and are able to persuade someone to go against his will and against his normal choice, such as creating a false sense of urgency. You say 24 hours, we are closing down in 24 hours and everything must sell, and the person is there compelled to buy. Or what is known as confirm shaming. Confirm shaming would be you are asked to make a donation and there's a column there which says, I don't want to donate to this charity, which is trying to put you to a self-shame. Then there are other newer thoughts which are coming up, which are all AI based, the harms. There are, for example, doxing, which is to take the publicly available information of a personality and to embarrass the personality by putting them on the net in an embarrassing sort of way. So doxing. Catfishing. Catfishing would be using someone else's identity to create your own. Or gaslighting, which is psychologically manipulating somebody so that the person loses confidence. Or salami slicing. Salami slicing, stealing small parts so they add up to a very large whole. So as you can see, AI creates a lot of opportunities, and yet there is so much of harm that it can create through false news and misinformation, where even countries have, the election result has gone the other way, as in Philippines, because of false or misinformation, or identity attacks and impersonation, and defamation, and all such discrimination, etc. So the growth of AI, it is absolutely essential for us to grow AI, but a lot of people are saying we must contain the growth, which is we must make sure that it is ethical and transparent and things like that, and also human-centric. So to end, the growth must not be organic, but has to be controlled by humans. Thank you. Thank you very much.
Thank you very much, Mr. Pravin Anand, for those very important aspects highlighting opportunities as well as challenges as we navigate through the path of AI, and most important, the idea of human-centric when we look at the entire narrative of growth. Thank you so much, sir. Moving ahead with the agenda, I now invite on Dr. G.R. Raghavender, Senior Consultant IPR at CPAM. He is Senior Consultant IPR in Department of Promotion in Industry and Internal Trade, Ministry of Commerce and Industry, India. He has also been Joint Secretary, Department of Justice, Ministry of Law and Justice, Mission Director for the National Mission for Justice Delivery and Legal Reforms, and most important, his very significant role in the introduction of important amendments in the Copyright Act in 2012 and the Copyright Rules in 2013. So on that note, without further ado, let's learn further from Dr. G.R. Raghavender, Senior Consultant IPR, CPAM. Dr. Raghavender, greetings, namaskar, welcome, and sir, please lead us through your thoughts. Everyone, with a round of applause, let's welcome Dr. Raghavender. Sir, please.
Vande Mataram. Congratulations to Legal Era and Akriti for this 8th edition of Global IP and Technology Conclave. And I've been associated with Legal Era for a long time, many years. And Akriti, I've seen her growing from young girl to a mature woman and handling the important issues pertaining to not only the IP, various aspects, And thanks to Pravin ji for opening up the session with very important speech which covers all aspects of law and technology. I know as a civil servant, I've seen in the indulgent policy making associated with the law and technology. And these disruptive technologies, artificial intelligence, and metaverse, and the non-fungible tokens, and augmented realities and virtual realities, and even edge computers. Without edge computer involving everything in the Internet of Things, and especially the 5G is already arrived. So all these aspects, these technologies are must. But what policymakers are doing? That's what Pravin ji mentioned about various issues and problems and wonderful things associated with these technologies. If you look at the EU, is already mentioned, EU has come out with the AI Act. And my colleagues in the US Copyright Office are seriously involved in public discussions, inviting comments on artificial intelligence, authorship, and various issues associated with it, how the copyright law should deal with these issues. And there are many other things, because AI has become part and parcel of every technology law, every sector. You see the present war in Gaza Strip, where Israel is using all the best AI technology for precision bombing the Hamas terrorists. Of course, the Hamas terrorists again, who started this war, use again technologies to attack the Israelis there. So the next war will be, already aware that if Russian-Ukrainian war also the artificial intelligence algorithm technologies are used. Imagine the kind of terrorist problems India faces, whether it is in Jammu and Kashmir and few fools sitting in Canada threatening India. If these people are start using these technologies, not only India, what will be the situation and a peaceful world if these technologies are misused? Pravin ji mentioned about the ethical issues, privacy issues, and all that. Despite the famous Puttaswamy judgment and Aadhaar judgment of the Supreme Court, gave a direction to India's Data Protection Act, and thanks to Ashwini Vaishnaw, the most dynamic minister of the IT, who pulled it back and introduced the most refined version of Digital Personal Data Protection Act, which has been approved by the Parliament recently. This is very, very important because look at the kind of data being generated, and everywhere is data. Well, now what kind of protection you okay, Data Protection Act protection won't enter the IP field. Obviously you don't get patent for that. The problems are issues related to that. If software based is there, 3K will come. Pravin ji will explain how the 3K issues have been solved almost by thanks to judgment recently. Ferdi Alani case, Delhi High Court has mentioned that the computer related invention manual and guidelines need to be more IP and innovation friendly. The aspect of technical effect which promotes innovation, that should not be killed. So the IP office have to make some changes into that, recognizing the innovation. Then if you don't get patent, then you obviously the TRIPS flexibilities. Article 27 talks about patenting all fields of technologies. If that is not allowed as per the 3 case, some extent, if there is no technical effect, you all guys rush for the copyright protection. But copyright protection, which was very beautifully defined in Article 10, Para 1 and Para 2, about including the computer database. I'm mentioning about the TRIPS agreement. But what happens when there is the basis of copyright protection, originality is not there? We don't have a law like non-original protection of databases like sui generis, a law which EU has introduced. In fact, WIPO tried to introduce a new treaty along with the WIPO Internet Treaty, WIPO Copyright Treaties, and WIPO Performances and Phonographs Treaty in 1996 diplomatic conference, led by India and many other countries who don't kill copyright, because you can't kill originality in the copyright and give non-original databases protection. It is for the member countries, individually localized laws can be given. But everything is data driven. What happens if a business associated with those data created, your secret, personal, organization, business-oriented data, it cannot be protected under the patent law or copyright. What is the way? We should have a trade secret law. And unfortunately, we have been enjoying the Section 27 Contract Act, Restraint of Trade, and other common law breach of confidence principles, which is not sufficient. Many times also mentioned. And we introduce one paragraph or sentence, whatever we call it, in National IP Policy, under the motto of Creative India and Innovative India, that India should explore the possibility of introducing trade secret law, especially this present day data-driven environment, the importance of secrecy of the data of many businesses. There is a need for introduction of trade secret law, and I understand that the Law Commission is working in this direction, advising the government. Hopefully, this will be done, because the laws have to protect the industry interest and various stakeholders' interests. But this has to be done by the Parliament, not by issuing simply office memorandums, what sometime back somebody has done for his whatever motives he had. That extension of Section 3D statutory license to the internet, simply instead of amending the Section 31D, subsection 3, and the rules, simply office memorandum was issued. This is a big mistake that has been done, and the Bombay High Court said that this is a wrong way of making policy. So, what we need to do in India should introduce an AI-related guidelines, regulations, and if possible, like EU, like AI Act. I seriously support that there should be an international agreement or a convention covering the AI protection, ethics, and the other security issues which Pravin was mentioning about the military exception for these AI regulations and guidelines, and also the privacy issues, ethical and privacy issues, because there should be harmony and minimum standards which laws like EU has done. US may be introducing tomorrow. There should be a harmonization in introducing these laws, because when doubles patent came, right from all the patent officer said that, IP is driven by there are many theories, but there are two important theories which drive IP, whether it is patent or copyright, other industrial properties. The incentive theory, basically investment and creating that IP, the incentive should return to the creator or inventor, because to address his personal interests, because as a living being and a human being, a machine cannot be an inventor. That's why the US, UK, EU patent officers rejected it. But surprisingly, Australian patent office granted the patent. Later they realized and they revoked that patent, and salute to the 5-judge bench which scrapped that patent, invalidated that patent. But surprisingly, South Africa has granted patent to those because their examination, whether procedure requirement are totally very hard. Even patent lawyers some get surprised many times. And number two, about the authorship of these AI-driven machines, whether algorithms, the machine learning, deep learning, like computer vision. The beauty of computer vision, handwritten script document, when it is scanned, it can read and create, whether it is a systematic data, whether it's supervised learning and supervised learning. The technologies of these things, which are writing, whether large language model based ChatGPT or maybe generative AI, I think some more important thing which are used, illegally creating deepfakes, which even Prime Minister of India, Sri Modi, has expressed his surprise and sadness of damaging the privacy and defaming people. So whether authorship given to the machine, again, I simply oppose, as my colleagues in US Copyright Office rejected recognizing an authorship to the machine, because as per the natural theory, the author has to be human. Only associated benefits given to the author, who is a person, who is a natural person. The person may be a legalistic, juristic person, but cannot be a machine, an author, because recently, again, another mistake done in India, that's the Copyright Office. Raghavender, Mr. Sani, advocate for an application. They gave, because the Parliamentary Standing Committee said that the government should promote innovation, considering the introduction of various emerging technologies. They said that Section 2Y supports the theory of joint authorship, because it is written with the prompt, because US Copyright Office, they were rejecting that either this is the man behind this creation of these doubles, artificial intelligence paintings, because either text prompt or voice prompt must not be given. This need, because the person behind this. Here they gave joint authorship, and later they realized that that is a mistake, and they revoked the patent. Again, another mistake, because Register of Copyright has not the power to revoke. You have to move an application before the commercial rights are very high. So the policy making is very, very important, and the government of India is already thinking about it, and in these kind of deliberations and discussions, obviously, when people like me are associated with the government, get a lot of knowledge from intelligent people who are sitting across you and convey your information and concerns. We note down and go back and try to deliver a good policy. And congratulations once again to Kriti Rajada and Legal Era for this excellent program, and wish you all the best. Thank you, Jen.
Thank you very much, sir. sir, for those important insights. And once again, thank you so much to Mr. Pravin Anand, Dr. Raghavender, sir. Thank you so much. There was technical snack on part of the hotel with respect to the podium mic. We are truly grateful to you for bearing with us, and of course, not letting this session stop and moving forward with the wonderful thoughts. Once again, a round of applause for Mr. Anand. Thank you so much, sir. And now, moving ahead with the agenda, I'm delighted to welcome among us once again for the address, Mr. John Cabeca, United States Intellectual Property Counselor for South Asia U.S. Embassy, wherein he is playing a very important role with respect to assisting U.S. companies for doing business in the region, advocating for effective IP policies. In the past, he's also worked at the U.S. Patents and Trademarks Office for 30 years. So on that note, let's welcome Mr. John, sir. Greetings and welcome to Legal Era Global IP and Tech Conclave 2023. With an applause, once again, welcoming Mr. John. Mr. John, please.
Thank you. You can hear me? Yes. All right, thank you. Good morning, everyone. I ran to get my phone, and I'll tell you why in a minute. But first, I just want to extend my own personal thank you to Legal Era, as well as how much of an honor it is for me to share the stage today with all the distinguished speakers, and take my own opportunity to welcome everyone to today's program. So I'm John Cabeca. I'm the U.S. Intellectual Property Counselor for South Asia. So I've been with the U.S. Patent and Trademark Office now. This is my 35th year. I come from the patent side of the house, but prior to coming to India about 3.5 years ago, I was the regional director for the U.S. Patent and Trademark Office covering the west coast of our country, and opened and ran the Silicon Valley branch of our agency. And I think it's important to just quickly to share that role is exactly what drew me to come to India, because the connection between innovators, researchers, IP services providers, and everything in between that exist in the Silicon Valley and the west coast of the country have very strong ties to India. And I saw a tremendous amount of momentum and very much wanted to come here and be a part of that. Very quickly, there's just 3 parts of my role here. And it's the biggest part is the government-to-government interactions that we have every day, not just in India, but throughout the South Asian countries, where we work not just with IP offices, but with regulators and other agencies that implicate or whose guidelines and laws might implicate intellectual property in some way. And then also working on helping to support strong enforcement of intellectual property. I also work very closely with industries trying to enter the South Asian markets, helping them understand our differences between our respective laws and how our court systems work and things like that, and also advocate on their behalf when it looks like there's something that might lead to a systemic improvement, which is a hat I wore a lot in my previous role in California, where U.S. stakeholders complained to me all the time what was wrong with the U.S. system, and then I would translate that back to the courts and try to make our system even better. And so I do a lot of that here as well. And then the third part is outreach education, helping to raise public awareness, often hand in hand with the IP office here in India, to promote the importance of intellectual property, help to generate a strong innovative culture, and to help share the need to respect intellectual property. So I wanted to paint that picture just very quickly. But turning to today's program, AI, we're talking about emerging technology, we're all talking about AI today. Soon we'll be talking about, and we've already started the dialogue on quantum technology and the impact that that's having. So it will constantly evolve. And when we look at how AI or how any of these emerging technologies fits into our intellectual property regime, we just have to look at our own history. When we look back at the invention of the sewing machine, there was huge opposition to the eligibility of a sewing machine. When we look at a sewing machine today, we see very clearly how it fits into the utility standards for utility patents. And then the same thing came true with the invention of the automobile. many, many years of legal cases challenging the eligibility of these innovations, which again we look at today, and we see very clearly how they're eligible. And it's kind of turning to some of the comments you've heard already in the software space. Even though software has been a major part of our lives for many decades now, 40, 50 years, if not longer, on a daily basis, the eligibility of software is still a challenge around the world. Even within our own system, our jurisprudence on software eligibility is has evolved in the recent decade and is still evolving, and it changes how we have to examine subject matter software-related inventions and the technical transformation that software implementation has on an invention to determine is it patent eligible or isn't it? And we see the same dialogue taking place today in Europe and in every IP office around the world. But even though our laws are slightly different, we're slowly converging into what that eligibility means. So the more that we're diverse, the harder it is for industry to obtain rights, enforce rights, to operate in those markets around the world. And I think when we turn to AI, that we're seeing that even more so, because obviously AI is a form of software, but its implications are much, much greater. And then turning to quantum tech, that remains to be seen the impact that will have on all of our lives as well. But I did want to, I ran to get my phone, I'll tell you why, because Pravin gave the definition of the EU Act, what AI is. And it seems like, to me, it's a definition that tries to constrain what AI is. And I feel that AI is actually very broad. So I like IBM's definition, so I thought I would just read that as a parallel. And so IBM says that at its simplest form, artificial intelligence is a field which combines computer science and robust data sets to enable problem solving. And I feel that that's exactly where we are today. And when we look at how we view AI from nation to nation, the more that we view it in a divergent way, again, will complicate things for industry, will complicate things to do business on a global scale. And so I do think that as our economies are working together, we also need to work together on a global solution. I agree with Raghavender in saying that we need some form of unity on AI, but getting to that unity is going to be challenging because our laws are evolving in different ways as well. But I do think that's something that we're very focused on. I'll talk a little bit about what we're doing in the US. But I also wanted to take a moment to underscore something that Pravin said with respect to the bias that AI has. And I think that if you're going to talk about AI, you need to actually test these engines. And so I've played with the image, generative AI, image generators, the text, the chat versions as well, and even the content generators that are coming out now. But I do see the AI bias. And I also find that when you interrogate AI, you get very different answers. And you might even convince the AI to give you a completely different answer from where it originally started. But I do think that when you look at the bias in AI, you also have to look at where is this content coming from. And most of the content, not most, but a lot of the content that it's scraping on the internet, but most of the content in the internet, especially when it comes to taking positions on issues, are usually on the contrary view. So I will see a lot of time the opposition to an issue that might be actually in the best interest of a country, but because there's so much press opposing that issue, the chat generated AI systems will say, oh, we should not permit this in our law or whatever. So I find that bias to be extremely challenging, and it's easy to see that if you test it on some of the issues becoming as strong as it can be. And so that's kind of where I want to underscore is it's really, the AI cannot tell us what's best for our economic prosperity, but that's up to us. And so the AI is only going to rely on what's in, what's in the public domain and what has happened. And as lawmakers and policymakers, we need to look to the future and look ahead to see what's really the best for all of us. So with that in mind, I thought I would just, we've heard many efforts globally, but I thought I'd tell you a little bit about what we're doing in the United States. We have a long history of developing cutting-edge and emerging technologies. The Biden administration has been very, very focused on AI, and even prior to that administration, we had the National AI Initiative, which has since been expanded to really address what are the AI implications across the U.S. government. And it doesn't just fall to the USPTO. It's not just a priority for the USPTO. It's something we've been monitoring and tracking filing rates, and even we'll talk a little bit about some of the things we're using AI for internally. But it's not just a priority for the USPTO. It's a priority for the entire U.S. government. In October of 2023, just last month, the Biden administration issued, and you're probably all aware of this now, an extensive executive order, it's about 110 pages, on artificial intelligence, specifically to ensure the safe, secure, and trustworthy development and use of artificial intelligence. And that executive order didn't just task the U.S. Patent and Trademark Office and the U.S. Copyright Office to come up with some recommendations. It tasked every single government agency in our entire federal government, including defense, to look at and to report back in response to this executive order on what exactly the implications of AI can be. And so I won't talk about the rest of the government, but I'll just broadly talk about what the steps were that the executive order charged the U.S. Patent Office and the U.S. Copyright Office to do. But basically charged us to issue and provide IP-related guidance and recommendations for AI-related innovations, and including guidance to patent examiners. And this guidance should provide examples. And that's one thing that I do like about our manual of patent examining procedure, for example, is it does have, when it comes to subject matter eligibility, there are slews of examples to help the examiner figure out which of these examples best compares to the claims before them, but also to help guide the patent applicant in how to better prepare claims to file before the USPTO. So we are working on that. We've been working on that for quite some time, and have had numerous public comment with respect to some of the steps that we should take with respect to providing guidance to our examiners. The executive order also tasked us with exploring other intersections of AI and IP, specifically in, for example, subject matter eligibility. And for the U.S. Copyright Office, they're also preparing a report for Congress. This report for Congress has been underway for quite some time. The comment period actually closed yesterday, I believe. I haven't heard if it's been extended. But the Copyright Office has been working very closely with the USPTO on the different copyright policy issues. So even though the Copyright Office is in our legislative branch, the head of the U.S. Patent and Trademark Office is the principal advisor, the undersecretary, is the principal advisor to the president on all forms of intellectual property, including copyrights. So we work very closely with the Copyright Office in our collaborative efforts as it relates to artificial intelligence. And through the past few years of public comment and stakeholder sessions, and we asked a series of questions to the stakeholder community. And we talked about inventorship, and we talked about ownership, and we talked about enforceability. But I think, when we talk at a high level, can AI be an inventor, yes or no? I think we're pretty much on the same side of that coin. But in reality, it's to what extent can an AI contribute to a copyrighted work? That's where it gets challenging. And we're seeing a lot of examples now coming into the courts that are challenging this yes or no example. And definitely when it comes to the field of law, the details are always in the gray area. And so it'll be interesting to see how that develops. You've heard some examples about where offices around the world have granted either a patent to copyright, to an AI, but then withdrew it. And I think that kind of happens. When you have emerging technologies, this happens all the time. It happened, in the software tech boom of the late 90s, in patenting of software as well, and helped frame our jurisprudence to what it looks like today. And I think we're going to see the same thing happen now. But that took 25 years just on the software side, after the big tech boom. So we'll see, with the acceleration of technology and the pace that technology is developing, we as policymakers need to get ahead of AI. It's something we're all trying to do. And I think the more and more we do that together, the better off we will be collectively as we try to strike that balance between stakeholders and industries. And when it comes to AI, even in the high-tech sector, there's a divergence of views on ownership and inventorship when it relates to AI, depending on the business model of each within the high-tech sector. And we're also seeing now amazing examples where AI is being used in biotechnology. So I think that our life with AI is something that we're just going to have to get used to. But hopefully we can do it in a way that we can work together, agree globally on a solution that makes it easy for innovative work, even employing AI to some extent, continues, and helps make our economic prosperity between all of our countries as strong as it can be. I'll stop there and thank you all very much.
Thank you very much. Moving ahead with the agenda, I now invite on Jyoti Pawar, Group General Counsel, Microsoft. Jyoti, she is a qualified solicitor in England and Wales, and also a member of the Bar Council of Maharashtra and Goa and Law Society of UK. And yes, currently she's spearheading a very important role as Group General Counsel at Microsoft. Microsoft is at the forefront of responsible AI, ethical AI. As an organization, Microsoft believes that they owe out to the planet, to the people and organizations to do more, to achieve more. And we all know that generative AI will be the buzzword for the next decade, and Microsoft therein is playing a very significant role. So on that note, let's welcome Jyoti Pawar, Group General Counsel, Microsoft. Jyoti, please.
Good morning. Pleasure to be here. As usual, Igorilla has again organized another conclave and with 90% attendance. So fabulous. Congratulations for that. What's this on the? Okay. Let's start. Keep talking. Go ahead and get this started. Okay, so I'm going to be deviating a bit from IP and going to stick to some general issues and a bit about Microsoft, of course. So we've had many definitions and we continue to have many definitions of AI. But I'm going to add to this one more definition because I just want to differentiate the AI from generative AI. Since we are talking about, I'm talking about generative AI in the next decade. Okay, great. Let me just test this once more. Where do I point? How do I choose the page? It's not slowly. Okay. Okay, Okay, so let me start again. Sorry for this disturbance. So let me start again on the definitions. Like I said, the only reason I'm doing this is to differentiate between the two. So AI is an umbrella term, right? It refers to machines or softwares mimicking human intelligence. A couple of examples of AI, which we use daily is facial recognition. The machine that does facial recognition, those of you who used DPIIT, you know how absolutely easy it is to just breeze through an airport with DPIIT. So that's one device. Self-driven cars coming up. I saw some videos saying LA has started self-driven cars. Very interesting. Robots. These are all examples of AI at its best, and there are several more. Generative AI, however, is a subset, and there are many types of AI. Generative AI is one of the types of AI. It doesn't just learn and understand data, it also generates content. Very interesting example of generative AI is OpenAI, ChatGPT. I'm sure most of you have used ChatGPT. There's Bard by Google, and there is the latest Copilot by Microsoft. Copilot is on all Microsoft products, and I'll just talk a little about Teams. Most of you here use Team conference calls. I would advise you to go and get Copilot because it gives you such a phenomenal summary of a 2-hour conference that you just, you can't possibly, after having done it once, you will get addicted to it because it's just so efficient. So that's another, Copilot is another example of generative AI. Let's look at the, okay, so, how do I go back? Right. I'm going to need some help. Can somebody just help with the slide? Just help me do it because it's just do it from the back end. Let's start again and do it from the back end. Yeah. Go back to the first page. First page. It's not the first page. Yeah, now let's just go to the next page, please. Yeah, so let's look at some of the data. Global spending of AI is expected to cross 100 billion in the next 2 years. And I think everyone should just absorb this number. We're talking about 100 billion and in the next 2 years. 37% of the organizations have already implemented AI in some form or the other. And this data is probably 2 or 3 months old. This must have definitely gone up. Rapid adoption with ChatGPT. In 5 days, ChatGPT actually had 1 billion users. It's just phenomenal, and that's why I call it a revolution, right? It's not domestic, it's not regional, it's actually across and global. And the companies that were formed between 16 and 22 have actually grown by 20% CAGR. So we are talking about big numbers. We are talking about almost like a thunder being created by generative AI as we go ahead, and by AI, of course. If you can go to the next page, please. Yeah. So what's the promise of AI? Right? This is it: healthcare, life science, climate change, agriculture, education, finance, energy, etc., etc. If I could just pick 1 or 2 of these, in the interest of time, I would pick, say, healthcare. Right? Look at the kind of innovation that is coming in healthcare. There is meant to be, we are all able to sort of talk to a doctor online. I don't know how many of you use that facility, but it's, again, quite interesting. Let's look at enhanced diagnosis that we're expecting with AI. A cure for cancer, Alzheimer's, etc., which has been forever, been going on forever, looks much closer today. Every other day you see a newspaper article that says we are closer to it, and that's actually powered by AI. Look at education. Education is the most interesting, and how it's sort of panning out. If people over here have heard of Bhashini, Bhashini is something that has been launched in 2022 by METI, so it is a Government of India initiative. It translates content in different Indian languages, so it actually converts voice to text and text to voice, which is absolutely phenomenal. It also translates one language to the other. There is another, and in a country of 1.4 billion with 11% speaking English, you can imagine what sort of a blessing this is. The other one is Jugalbandi. This is an initiative between Microsoft and the government, and you know it has a chatbot where anybody can, in any language, ask have an access to all the government websites for all the information. And you don't have to rely on the children in rural villages where someone educated comes along. Then you rely on those people. You don't have to rely on any of that. You just need a phone, a chatbot, and you just keep asking questions in whichever language you're comfortable with. And you'll get the answer back in the language that you're comfortable with. It's phenomenal, and this is all a part of generative AI. Climate change is another very interesting one. Analysis of data from sponsors. SEEDS is another very good organization that does this analysis. Risks related to climate can also be predicted today in much better terms and much reliable terms than ever in the past. I'm going to move on to the next slide. Let's look at general legal issues. I mean, the highly esteemed panel has definitely spoken and covered this in a fantastic way when it came to IP and data. But when you're talking about legal issues, AI relies heavily on data. It's completely data-based, right? What you put into the system is what you get out from the system. So cybersecurity and data protection become big issues when it comes to the first legal issue that I'm talking about, right? So when it comes to cybersecurity issues related to malwares, firewalls, phishing, spooking protection, encryption, and when it comes to data protection, it's informed consent, right? It's, again, accuracy of what has been put in as well as what have you removed or what have you searched for. It's also about breach reporting. Again, different countries will have different laws on breach reporting, or different sectoral regulators may have different laws. But reporting has become absolutely mandatory, otherwise there's no other way to track this. So data privacy per se has become much more important than ever before, and I'm really glad that India has a Data Privacy Act. Safety and fundamental rights are again massive, and I think Mr. Pravin touched upon bias, etc. And these are again important issues that are going to come up with this. Product liability and accountability. Who is responsible? That's the question, right? When it comes to AI. So if you look at a product that is made, which is say a hardware or a software, if there's no defect in the manufacturing of that or making of that, right? The person who has made it can get away with it, right? Because it's like a car, right? It's been manufactured with zero defects. Meets with an accident, everything is checked in investigations, everything worked fine, it was just an accident, all is good. It doesn't work like that with AI, right? AI made defectively or modified by a license can cause harm, and the liability then rests on the licensee and the licensor. And this is what I'm speaking today. We still don't know. This is a gray area. We still don't know which way this law is actually going to evolve. IPR, I'm going to just skip. I think there are many specialists over here and not spoken on IPR, so I'm going to skip that. But interestingly, things that what Mr. Pravin Anand actually mentioned. Who is the inventor, right? Who is the author? Who's the user? It's extremely complicated. And everything is happening in different countries, right? It's not happening all in one city or one country. One could be user could be somewhere, inventor could be somewhere. Cause of action could lie completely at a different place, right? Issues with respect to registration, licensing, and if you actually cross all these hurdles, the question is enforcement, right? How and where do you enforce? Litigations, we don't know what we're going to expect, but it's going to be very interesting to see because it's really a gray area. It's going to be interesting to see how regulations evolve and how litigations evolve. I think everybody, as lawyers, we really need to start reskilling ourselves on what AI is, because that's the biggest piece of litigation that we can expect in the future. And regulation is evolving globally. With that, I'm going to just a good segue into the next slide, please. Yeah, the regulatory framework. I think over here, the first point really is on harmonization across nations. Extremely important to have this at this point. When I'm talking about harmonization of what? Of the regulation of the basic governing principles of AI. I think that needs to be pretty common across nations, otherwise it's going to be quite a lot of chaos. Nuanced differences are okay, but broad principles that apply to the value chain, which is the developer, the deployer, and the user, all three need to be absolutely in sync on principles, right? Again, ChatGPT is another good example of why it needs to be in sync. It's only because the users are spread everywhere. The deployer, the developer, and user again is everywhere. So it is important. Legal issues are common to countries, right? Even another reason, interoperability. This is extremely important when it comes to AI. It is very critical for businesses to be able to deploy and develop AI solutions effectively in any jurisdiction. If you have a setup where there is no harmonization, then, or if there is a country, or you as a developer have to really navigate diverse, contradictory regulatory landscapes, that could become difficult. Crisis management is the other one. If crisis management, laws are different in one country versus the other, when it comes to AI, there has to be again a common principle, so that a country can take help from the other country. Let's look at what happens if there is no harmonization. There's a risk of misuse by malicious actors. Mr. Raghavender referred to malicious actors in his presentation. There could be differential treatment of high risk, right? Use cases like biometrics identification. Facial recognition, another great example, right? It's great for ease of access into airports and malls and theaters. But if it's used for racial profiling or qualifications or decision matrix, it's not good. So again, one country having an advantage over the other. So companies will find it difficult to work in different jurisdictions. I do want to also talk about shared responsibility. It's extremely important for everyone in the value chain to share the responsibility. It cannot be that a service provider or say a system integrator who has a small role to play, versus somebody who's actually developed it, have the same penalties. So it is important that the responsibility is shared. It is important that the compliance as well as the liability that is distributed amongst them is actually risk-based. The EU has taken a risk-based approach. There are different AI systems where different risks apply. They're classified into, I think, 4 such classifications. The first one is supposed to be the high-risk one. Give me 1 second. Yeah, so we have the unacceptable risk, which is practices that are clear threat to the EU citizen rights. These are banned. Then there is a high risk, this is system affecting safety, where they are proposing a stricter regulation. Then there is a limited risk, basically, which is transparency of obligations, and then there's a minimal risk, which is self-regulation. So putting all this together, I think it's important that the compliance responsibility, the liability is proportionate to the risk that is involved and to the role that is performed. I think both become really important. Can we go to the next one? So talking about accountability, responsibility, ownership, I do want to share the Microsoft copyright commitment. Microsoft is extending its existing intellectual property indemnity to support co-pilot services. Now, what does this mean? In any contract which any company signs, if the product is manufactured by the company anyway says, this is my product. If my customer gets a third-party claim, I will protect my customer against any copyright claim. This is very standard. You'll see this in all the clauses, right? In Copilot, however, data that is residing, that everybody is using Copilot for, that data doesn't belong to Microsoft. Microsoft is saying, in spite of that, to all Microsoft customers using Copilot, we are extending this indemnity beyond. I think it's a very unique and very interesting clause. When I first read it, I was quite amazed. I'm 9 months into my role, so I was even more amazed, thinking, why is Microsoft doing that? But it is doing that, and there are a couple of reasons for it. Let's just go to the last page over here. Yeah, so the reason why Microsoft is offering its Copilot, customers Copilot copyright commitment are threefold. The first one is that we believe in standing behind our customer when they use our products. The second is we are sensitive to the content of co-authors, and we want to assume responsibility for this. And that's why the term responsible AI, which has been used extensively, but this is an example of responsibility. And the last one is confidence, complete confidence in the guardrails that we have built when it comes to Copilot. With that, I'm just going to close my bit of it. Pleasure to be here and really looking forward to interactions during the lunch session.
So thank you very much, Jyoti Parwar, Group General Counsel, Microsoft, for those very important insights. And yes, and we'll be having questions, but that's going to be happening during the networking tea and coffee break. At this hour, for the important concluding remarks for our opening plenary, I'm delighted to welcome and request Shri Hari Subramanian, Managing Partner, Subramanian and Associates, a leading IP boutique firm, and Mr. Subramanian has been in practice for 4 decades really, specializing in all aspects of intellectual property laws, and he's the incumbent president of the Asian Patent Attorneys Association. So on that note, once again, sir, greetings, namaskar. With our applause, let's welcome Hari Subramanian, Managing Partner, Subramanian and Associates. So please.
Thank you. Good morning, Akriti, Legal Era team, for pulling off this such a brilliant conference, such a fantastic start. I was privileged to share the dais with Chairman Pravin, Anand, Chair of this conclave, Jyoti, Raghavender, John. Each one of them, spoke in less than 10 minutes time. Such brilliant aspects of AI, both the legal, moral, ethical, and various aspects. It's a fantastic learning experience for me. I had to recalibrate myself before I came here. There have been a lot of conversations globally happening about AI in the last few years, but is AI really as new as we think about? I was reminded about an incident in 1983 when I was traveling to San Francisco. There were only 2 flights from India. One was Pan Am and there was Air India. I was on an Air India flight. And I was in the Delhi airport and the flight was delayed. I was supposed to reach San Francisco on Thursday for a meeting. I reached there on Saturday morning because there was a strike by Air India employees. The strike was about the fear that Air India was going to computerize the systems. And the newspaper, all the headlines were screaming, is computerization really good for the society and will lead to a lot of loss of jobs. And that was the state here. And the general consensus, going by the newspaper reports, I collect newspaper cuttings all the time, was that it is bad policy to computerize, particularly for a country in India. Well, I missed both the meetings in San Francisco. I reached on Saturday morning, and there was this international computer chess tournament happening there, 17th. So in 1983, there was the 17th inter-country international computer chess tournament happening, and there was a computer called Deep Blue fighting against a computer called Ostrich. It was an incredible experience watching those 2 computers. There was no human intervention, except the pre-programming of the data inside the computer. it was brilliant watching two computers play against each other. I think that was my first exposure to artificial intelligence. Well, if you read about it, IBM, ages ago, in the early 1900s, 1920, 1930, IBM was selling more meat and cheese than computers, really. Until a gentleman called Herman Hollerith invented a digital calculating machine, which IBM bought. And then, of course, it reached acceptance as a computer business machines operation. Now, is it a calculator and artificial intelligence as well? Probably if you look at the calculator then, now, and artificial intelligence as we understand it now, probably the difference is that the artificial intelligence that we know today keeps learning as it works. Unlike the old computerized machines, which won't learn, which only perform tasks according to the data that's fed in, according to the software coded in it. But then, when a situation reaches a particular proportions, it adds to a lot of fear, more fear of the unknown, a lot of anticipation, and lots of conflicting situations, messages, judicial precedents that come about. And of course, it's interesting, it's very enlightening, and it's sometimes scary as well. We have a very similar situation in, again, early 80s, 90s, when we were facing the same situation, challenges with biotechnological invention, when this cloned sheep, Dolly, was patented. Now, we were wondering whether biotechnology is going to take over the world completely, and we are going to have cloned human beings completely controlling the world. I think the situation with AI is more different at this point of time. We attend several conferences, several meetings, talk to clients, talk to people all the time. And there are multiple concerns, questions that are raised about AI all the time, which our panelists covered, most of them in 10 minutes. That's absolutely brilliant, 10 minutes each. We covered about AI in terms of copyright, in terms of various IP. One of the big issues that we talk about is, can AI sue today? If an idol, a deity in a temple can sue, can litigate, can an AI litigate? Then raises the next question, can AI be an inventor? Can an AI be an inventor of an invention? And can AI own inventions? And can AI patent invention in its own name? Now, there's a school of thought which says that AI cannot be an inventor because a human being who created an inventor in AI, and therefore AI creates invention, therefore the human should be the inventor. But then, if my child invents something, because I created my child, do I become the inventor or my child is an inventor? The legal possibilities, the legal interpretations are amazing, far-reaching, beyond human imagination. What scares me today is not about what AI will do, but how the law is going to be interpreted in various situations. Talked about Section 3A of the Patents Act, 3A of the Patents Act. I was involved in the little amendment in 3A of the Patents Act 20 years ago, in around 2020, when I was making this presentation before the Joint Parliamentary Committee. I gave examples of how computer software is interpreted all over the world, and I recommend that the word per se should be added after the term computer program in Section 3A, which the Parliament agreed and added, in order to make it very clear that the purpose of the legislation is only to avoid patenting computer program by itself, the simpliciter, and not computer program-based inventions if there are other technical effects as well. But in spite of this amendment, the Indian Patent Office still refused hundreds and thousands of cases because they did not understand the meaning of the word per se, until Pravin then took up the matter before the court. And that took a whole lot of time because the matter was before the Patent Office, went to the appellate court, came back to the Patent Office, then had to go back to the court. By the time, he succeeded in establishing what per se really meant, with a judicial order, the term of the patent had already expired. So that brings us to a different different situation. When we as lawyers argue cases before the court, Jyoti touched upon the social responsibility as when we are dealing with topics like this, whether we are lawyers with the judiciary, we are part of industry, with a common representative, we are the all here. We all have our own responsibility. When we argue case before the court, we have our responsibility as well. It's not scary when you have brilliant lawyers like Pravin or Hemant Singh or somebody arguing the case. But when we are talking about a situation which is little unknown to the judiciary, and brilliant lawyers cannot always argue a case, and sometimes you have a not too well instructed lawyer arguing a case before a not well instructed judge in a district court somewhere in some corner, you end up creating a bad precedent. And the bad precedent comes back and bites you for a long time. It takes a very, very long time to, get rid of it again. So, while laws can be there, policies can be enacted, things don't happen in a day's time. The laws and the policies undergo several interpretations, several judicial changes, several parliamentary changes, and we're going to keep talking about them. So you look at guidelines that AI is a software. I personally believe that the very concept is completely wrong, because AI cannot work as a software. There is a part of the AI, integral part of the AI is software, but it cannot work without implementation of relevant hardware. A simple example is talk about the cell phones that we have today and the cell phones we had 20 years ago. 20 years ago, we had cell phones which would help you make a telephone call. Now, your cell phones today can do immense amount of things, and they are not just based on software. There's always also a lot of combination of new hardware as well. So to define AI as a software predominantly would create issues as well. So one can have law can create legal fiction, like we have in section 3D, like talking about salts and ethers and esters as same as the original compound unless there's a new efficacy. Then there's an interpretation of what's the derivative. There's an interpretation about what is efficacy. These things keep changing by judicial decisions and of course legislative enactments. We expect to face the similar situation in respect of AI-related legal issues, social issues, ethical issues. And even the ethical issues sometimes are very different. It's like having a glass of water, half a glass of water, and depending upon your thirst, it's either half empty or half full. I was dealing with a case years ago on a method of tenderizing meat. The meat when it's exported, the meat is packed at a particular temperature and then it's kept stored in a particular temperature, but when it's transported across different continents, the packaging, the entire boxes, all the cargo is taken off the freight, taken off the ship, the planes, then it's got to pass through the customs, then come back and then load it back into the train and then put back to the freezer. So when it undergoes different temperature changes, the meat when it arrives at the destination is no longer tender. It's very hard. This was an invention which was about tenderizing meat. And the animal is injected, a live animal is injected with a hormone which makes the animal suffer until it dies after 7 hours in a daily. It's struggling, it's just banging itself against the floor and the wall before it dies. But the result is that the meat is as tender as butter, regardless of what temperature it's stored. The European Patent Office rejected this patent on the ground of morality, saying that the suffering caused to the animal far outweighs the commercial gains and therefore it's immoral. The Australian and New Zealand Patent Office granted patent on the ground that the commercial gains far outweigh the suffering caused to the animal and therefore it's patentable. Same issue looked at from 2 different directions. And of course, the US Patent Office granted patent because everything under the sun is patentable. Moral issues notwithstanding. So you will have judicial precedents from different countries on the same facts with completely divergent results. So what we are going to be facing in the next 20 years, 30 years, regardless of the fact that AI-based technology is progressing at such a rapid speed, is going to be interesting. At the same time, it's going to be challenging and somewhat frightening. So here we talked about a lot of situations. We may not have answers to all the questions that you may have. I don't have answers to a lot of questions that I personally have, but with this, I'm grateful to the extremely brilliant panel over here for conveying something. I must congratulate them for this because I remember an instance where I argued my first ever case in 1983. I'm not a really litigator like Pravin, but I was supposed to be in the court one day and I had to argue a case because my senior, Mr. Chidambaram, was busy on his legs in another court. The judge said, no, you argue, I'll give you 10 minutes. I was shivering, but I started arguing. I was very clear on my facts, on my science and law, and started arguing, but I could finish it in 10 minutes. It took me about 45 minutes. I got ordered in my favor by the time Mr. Chidambaram came in. I asked Mr. Chidambaram, sir, how was I? He said, you are a bloody disaster. I said, why? I got an order in my favor. He said, that's because you are a very lucky day today. Maybe the judge is in a good mood. He says, next 20 years, please watch the lawyers argue. The best point may not be the best point to start an argument with. And if you cannot get a judge on your side in 5 minutes, the case is slipping away from you all the time. And the topic on AI is so vast, we can talk about it endlessly. Yet the 4 speakers standing here, led by Pravin Anand, it was brilliant hearing them. Thank you very much. I think you covered in 10 minutes more than what I could say in 10 hours. Thank you very much.